Thanks, Yasmin. Yeah, I'd like to acknowledge the traditional owners of the land that I'm broadcasting from, the Gadigal people. I'd like to pay my respect to the elders of this land, both past and present, and extend that respect to other Aboriginal and Torres Strait Islander people present today. It's exciting to bring today's webinar. It sort of came out, the idea for today's webinar came out of the Migration Institute of Australia chat comment that it would be nice for migration agents to know more about, I guess, Centrelink eligibility for visa holders, other forms of financial help, Medicare, schooling and access to school fees, the NDIS and housing. So this has sort of come about through that comment, and we're sort of hoping to provide a bit of an overview of the background of eligibility for people who haven't yet obtained citizenship in Australia. So there's a bit to get through, but like Yasmin says, please just stick any questions in the chat, or we have quite a expert group of attendees today. I think we've got people from the Red Cross, people from a range of organisations. So yeah, corrections are also welcome in the chat. All right, so to kick off, just a broad brushstrokes overview in terms of Centrelink, which is the first area that I'll talk about. Temporary visa holders, the general rule is that they're not eligible for Centrelink payments. So that's just a blanket general rule that you can try and remember in terms of what's possible and not possible for temporary visa holders. There are exceptions, but as a general rule, if you hold a temporary visa, you can't get Centrelink payments on an ongoing basis. And the general rule for permanent visa holders is that there's generally or normally a 4-year wait before you can start receiving ongoing payments. And there's normally a 10-year wait for pensions. So that's just sort of the broad general rule. And then we'll come to, I guess, what are the exceptions. Starting with the temporary visa holders, so which temporary visa holders can actually receive payments, even though they're normally not eligible. So some temporary visa holders can receive Centrelink payments. The first group would be temporary partner visa holders. So these are people who have been granted the temporary partner visa already. 309 if it was granted from outside Australia, and 820 if it was granted onshore. So they've been accepted as being the partner of an Australian, and they already hold that temporary partner visa. They could receive special benefit if they've experienced a change in circumstances after coming to Australia and they're in hardship. The second group would be temporary protection visa holders. So TPVs is temporary protection visas, and SHEVs are the safe haven enterprise visas. These are people who have been accepted as refugees but don't hold permanent protection visas, and they generally receive special benefit from Centrelink. Criminal justice stay visa holders can receive special benefit. New Zealanders is a fourth group of temporary visa holders who might be able to receive payments from Centrelink. That's a complicated one, so we'll come to that. For these special benefit payments, you need to be in financial hardship, but generally they're the groups of people that can receive Centrelink payments, even though it's a temporary visa. And then I guess the other group that I wanted to mention is if you've got an Australian citizen child, there's every chance that the visa holder can receive special benefit, not paid in their own name, but in the child's name. So it's important to remember, I guess, if someone has an Australian citizen child, they could potentially remain here on the special benefit in the child's name. And that's paid at a discretionary rate. So you can make sure it's paid at the maximum rate possible, which would be the same rate of job seeker payment for a single person with a child. Yeah, so there's sort of an overview of some temporary visa holders who can receive Centrelink payments, which are the exception to the general blanket rule, no. So for example, if Anjali comes to see you having fled a violent relationship and she asks what Centrelink payments she could access, I guess what would be your answer if she's applied for an onshore partner visa but hasn't yet been granted the temporary visa and holds a bridging visa A? And what would your answer be if she's been granted the temporary partner visa and is waiting on the permanent partner visa grant? Any ideas to A and B? Stick them in the chat. Can she get any Centrelink benefits? All right, well, I might help you out. So yeah, the difference there is whether or not she's been granted the temporary partner visa. So if she's applied for the partner visa but hasn't yet been granted it, no Centrelink payments, unfortunately. If she's already been granted the temporary one and is waiting on the permanent one, then she could access special benefit from Centrelink. All right, next case study. T has an Australian citizen child who she cares for. She's separated from the child's Australian father. She holds a visitor visa and is in financial hardship. What Centrelink payments could she receive in Australia? Is she eligible for any permanent residency pathway based on her parentage of the Australian citizen child? Any ideas there in the chat? Oh, I think I've got a question in the questions. Sorry, I was looking in the chat. Just looking at the questions. Yeah, so that's right. Beatrice has said it that she could receive special benefit in the child's name, and that would be the ongoing payment that she could look to receive. That would be, I mean, to get FTB, sometimes people ask about FTB. To get FTB, the parent has to be a permanent resident or a New Zealander, and that's not her. So special benefit paid at the single with child rate is the best payment option for her. Is she eligible for any permanent residency? Look, I guess not really on the face of it, no. So it would depend on asking a few more questions there about, you know, protection obligations, skills, employer nominated, graduate student, or, you know, other pathways. But based on that, can't see any permanent pathway based on what she said already. I want to talk about New Zealanders. So New Zealanders are a strange bunch because they can receive some supports but not usually income support in Australia. So New Zealanders, when they come to Australia, don't require a visa. They just are granted the 444 visa automatically when they come to Australia. But they can access some supports in Australia, and I'll just go through what they are. So the healthcare card or a seniors card tends to be a card that people can receive in Australia. Once someone has been here for 10 years in Australia, they could receive 6 months payment as a one-off of job seeker or youth allowance, but you have to be here for 10 years first. They could be receiving the same payments as Australian permanent residents if they've been here since, or they arrived here before the 26th of February 2001. So then you're a sort of special and protected New Zealander. If you are a New Zealander who is caring for a child, then you could be looking at getting FTB, childcare subsidy, the family assistance payments. And then there is the international agreement, which some people could receive DSP, although it's very difficult to qualify. The rules are greater than to receive DSP normally through Australian payments, and possibly the age pension based on how long you've lived in Australia and New Zealand as a working age period of time, and what periods of time you've lived in Australia and New Zealand. So, case study, Jerry is a New Zealander. She is 30. She came to Australia for the first time from New Zealand in 2017. She asks you if she's special, if she's protected, if she's eligible. She's heard these words used about New Zealanders. She doesn't know if she's one of them or not. She asks you, what visa do I hold? How long can I stay? Can I access Australian social security payments? How old? Let me just see. Just seeing what's there. Okay, so as a special category 444 visa holder, Jerry can stay in Australia indefinitely as a New Zealand citizen, as long as she remains a New Zealand citizen. New Zealanders who arrived in Australia after that key date of 26th of February 2001 aren't regarded as eligible New Zealand citizens or protected, so she would only be regarded as a temporary resident here. She can access Medicare, she can access a healthcare card and the one-off payment of job seeker from after she's been here 10 years, but there'd be no ongoing social security payments that she could use while in Australia or receive while in Australia. So in terms of the rights of New Zealand citizens in Australia, on a 444 visa, which is the visa that New Zealand citizens hold while they're in Australia, a New Zealand citizen in Australia can get Medicare, they can work, they can stay as long as they like in Australia, they can come and go between Australia and New Zealand, they can apply for visas in Australia, including permanent visas if they're qualified. They can sponsor immediate family, their wife or partner and dependents for a 461 New Zealand family relationship visa. But the things that they can't do on a 444 visa are get most social security payments. They can't vote. They can't stay if their visa is cancelled. So like any visa, it can be cancelled. They can't become a citizen unless they qualify first for permanent residency. They can't access the NDIS, and they can't sponsor relatives for permanent visas. So that's sort of an overview of the situation for New Zealanders in Australia. And if you are a protected person, so the date that is often mentioned is that 26th of the 2nd, 2001, the things that you are able to do are that you can get most social security things. You still get most social security payments. You can't vote. You still can't stay if your visa's cancelled. You can become a citizen, so there's no need to get permanent residency first. You could go straight to citizenship. You can access the NDIS. And you can sponsor relatives for permanent visas. So that's sort of a difference between if you're one of the old system pre-2001 New Zealanders, they're the things you can do and you can't do. So that's, I guess, some temporary visas and the exceptions to the rule that you can't get Centrelink payments if you're a temporary visa holder. Now we're going to talk about exceptions to the general rule that you have to be hold your permanent visa for 4 years before you can get payments. The permanent visa exceptions include refugees and their family members. So that means that's for all payments. They could receive them straight away without having the waiting period. The second exception would be if you'd become a lone parent after becoming a permanent resident. And so normally the payment that someone is receiving if they've become a lone parent is parenting payment. You can also get job seeker or youth allowance, but parenting payment's normally the payment if the youngest child is still under 8. You could receive Centrelink payment straight away without the waiting period if you became impaired for work while you were a permanent resident, and that's the disability support pension. So that means if you became unable to work while you held your Australian permanent residency, there's the exception to the normal 10-year wait period for qualifying residents for disability support pension. Carer visa holders can receive carer payment and carer allowance. And then the final exception that I've sort of put in this simplified version of the exceptions is if you've had a substantial change in circumstances beyond your control, you could receive special benefit within those waiting periods. Just seen in the chat, I've discovered that an SC866 visas holder family that came on a partner visa can't access Centrelink payments. They have to wait 4 years. I guess the rules about the family members of a refugee at the time of claim, I mean, some of the case law on this has included whether or not they were a family member at the right time or whether they'd become a family member later. And there have been a bit of litigation at the AAT on that. But ordinarily, it shouldn't matter what visa a person came on, as long as they meet the definitions of family member of a refugee within the Social Security Act. I'll put that in the paper that I'll send around later so that people can look at that requirement to be a family member of a refugee or humanitarian visa holder. But if you are a current, I guess family member of a refugee at time of claim and when the person became a refugee, it shouldn't depend on what visa the family member holds necessarily. But yeah, happy to look into that one further, Colin, because that sounds interesting. So case study, Mohammed was successful in his application for a protection visa. Now that he holds a XA866 permanent protection visa, what financial payments could he receive from Centrelink? Is there a waiting period? Assume he's 23. Would he be activity tested on the payment? Who could help him if he has problems with Centrelink? Okay, so the answer on this one is, yeah, Mohammed would qualify for job seeker, which is paid to people 22 years or over, but underage pension age. As a refugee, he would be exempt from the 4-year newly arrived residence waiting period. And as a refugee, he would have an automatic 13-week exemption from the activity test. After that 13-week period, he would be subject to the activity test on the job seeker payment. And I guess if he has problems with that activity test, there are a couple of organisations he could reach out to. Welfare rights, there are welfare rights centres around Australia. There's the one in Sydney for New South Wales. Or if he's at AAT Tier 1 or 2, there's us, Legal Aid, who could give him some advice about that. I guess one factor that I haven't really gone into because it's quite a complicated area is international social security agreements. So Australia has, I think, 31 countries that they've got agreements with, whereby a person could, depending on if they've lived in those countries and Australia for certain amounts of time, receive payments paid through Australian Centrelink, but under an international agreement. So if you have a client from any of these countries, it might be worthwhile if they have already been told they can't get any money from Centrelink, just double checking whether there would be any possibility of them qualifying under the international agreement. The agreements are really complicated in terms of how many years you need to have resided in each country and which payment you're going for. So I'm just going to sprinkle around the names of the countries just to plant some seeds. I think the New Zealand agreement is the one that I've had the most experience looking into for age pension, or for people planning to get the age pension. But yeah, bear in mind, if a person couldn't receive ongoing payments, they could receive it potentially under one of these agreements. Okay, so that's all I wanted to say on Centrelink, just to sort of plant some seeds out there about what possible payments your clients might be eligible for. And in terms of if they're not able to receive Centrelink, well, what could they receive? I guess the two things that I wanted to speak about were SRSS payments. They're predominantly paid to asylum seekers at the moment, and also Red Cross, which may be available for help, including family violence help. So for SRSS payments, a person might be eligible if they hold no visa or a bridging visa E and are living in the community. They might be eligible if they've applied for a TPV or a SHEV or a permanent protection visa. And they might be eligible if they're facing significant barriers that are impacting their ability to resolve their immigration status, maybe if they've recently been released from immigration detention. If the person wants to claim SRSS payments, they need to contact a provider. The lists of providers are on the department's website, and the two providers in New South Wales are Life Without Barriers, or SSI, and those are the numbers that we give to people wanting to make that application. And we tell them to take in their bank statements, proof of their immigration status, passport if they've got one, bridging visa grant letter, and acknowledgement that they've applied for a protection visa. Okay, so case study, Maria. Maria has recently applied for a protection visa onshore. She asks you if there's any possibility of receiving financial payments while waiting. What can you tell her? If her application for payments is refused, could she appeal? Who could she appeal to? Okay. So, I mean, I think we've worked out she should apply for SRSS payments by contacting a provider. SRSS payments aren't social security payments, so there's no right of appeal in the same way that you can go to the, you can appeal any social security decision you disagree with through the an authorised review officer and then the Administrative Appeals Tribunal. But so with SRSS payments, there's internal reviews that are possible. Through Human Services could do an internal review on eligibility, and following that, Immigration could conduct a review of ongoing eligibility. So normally we refer people to contact both Immigration and their SRSS provider and say they want to seek a review of eligibility and provide evidence of their current circumstances. If they're not satisfied with the responses, then raise the issue with those contact organisations in writing. And I guess seeking internal review with Human Services and then the Minister for Finance is who it's administered by. There's sometimes people ask us, well, I want to appeal a debt or I want to appeal a cancellation. Essentially, it's the same sort of process, and getting back on payments should be done through contacting the provider again and establishing your current eligibility in the meantime. Case study, Delilah. So Delilah fled a relationship which was violent. She holds a student visa. She asks you if there's any possibility of receiving ongoing financial payments. She has nowhere to stay. What could you tell her? Okay, so this is where I'm suggesting that Delilah could be referred to the Red Cross for help. So help's available for anyone who is not an Australian citizen or permanent resident, which would be Delilah if she holds a student visa, if she's experiencing or at risk of family or domestic violence, experiencing financial hardship. So I've just put the link up there for the family and domestic violence help through the Red Cross. Just going back in time for SRSS payments, Lynn has said in the chat she understands it's an issue for the payments if a client sent money home at any time. Is this also a problem, for example, for a protection visa interview or other DHS processes once a person has work rights and can earn an income? Yes, so that's our experience too, in terms of we found that people have had their payments cut off following transfer of money overseas. So anyone who transfers money overseas will generally have a review of their SRSS payments triggered if the amount of funds transferred totals 1,000 or more in a 12-month period. The payments will be cancelled as they're considered not eligible for the payments anymore. On the application form, you have to declare all details of bank accounts, and if your payments have been cancelled based on transfer, then you need to tell your SRSS provider urgently how you came to have those funds, and to the Department of Home Affairs in writing, and ask that payment be restored. So for example, you know, we've had a few cancellations reversed where the asylum seeker was able to demonstrate that the money transfer was a donation to charity, or there's more to the story than what it looks like through the transfer of money overseas. We have had a transfer of money come up in protection visa interviews. So it is good to, and I think, I understand sometimes RACs FOIs those or ask for the records of transfers in advance for many of their clients to have a heads up on what might come up in the protection visa interview. It depends on the facts of each protection visa case whether that would be relevant or not. But yeah, we have had experience with the department having access to that information and it being presented to a person in their interview. All right, back to, so Red Cross is available for family violence help. Turning to the issue of Medicare, so non-citizens might be eligible for Medicare if they meet one of the following sort of general boxes. New Zealand citizens in Australia are eligible for Medicare. People are eligible for Medicare if they hold a permanent visa in Australia. People would be eligible for Medicare if they have applied for a permanent visa in Australia. The exception to that is you can't have applied for a parent visa. Parent visa means anything with the word parent in its name. And also you've got to have work rights on your bridging visa in order to access Medicare on that basis. So that's why people sometimes do require the work rights on their bridging visa changed, because they urgently need to access Medicare while they're waiting on that permanent visa to be processed in Australia. The other categories would be people who've adopted a child and partners of Australians. So work rights on a bridging visa is something that we get asked a lot about by support workers who are trying to help people access Medicare if they have medical needs. So if you hold the bridging visa A, C or E, you can apply for a new bridging visa without the work condition on the basis of a compelling need to work, which means that you're in financial hardship, and the form that you'd complete there would be the form 1005. If the person's also applied for a protection visa, they need to satisfy the Minister there were good reasons for the delay in applying for a protection visa, and unfortunately the policy on what good reasons are is not that generous. Acceptable reasons in policy include that the situation in your home country changed after you arrived, or a medical reason you couldn't make the protection visa application earlier, but not knowing about the process, limited English, they say are not acceptable reasons for a delay in making a protection visa application. So they need sort of stronger evidence about the medical reasons why a person wasn't able to access earlier. If a person hasn't applied for any kind of substantive visa, a visa that's not a bridging visa, then the work rights on that bridging visa will just give them the right to work, not rights to Medicare. Okay, so Lily, no work rights. Lily came to Australia on a 600 tourist visa. She's needing to stay in Australia for the family law proceedings, which are about her Australian citizen child. She's seeking a relocation order that she'd be allowed to return to Thailand with her child. She's applied for a further tourist visa, 600 visa, but is currently on a bridging visa A while she's waiting. It has no work rights. She asks if she could apply for work rights on the basis of a compelling need. Any thoughts there? No rights, no rights is coming up. So often bridging visas have the same conditions attached as the previous visas the person held. So here, if they held the 600, the bridging visa attached would normally be the same no work condition. It is possible to ask that that condition be removed on the basis of compelling need. If successful, it wouldn't give her access to Medicare on that basis, but the child should ordinarily have Medicare access themselves as the Australian citizen. But I guess the migration agents or lawyers amongst us might think, well, if you're trying to demonstrate you've got sufficient funds to support yourself, which is part of the qualification for a visitor visa, it might not be great to also be saying, I can't support myself in Australia. So if she really needed to work, it may be worthwhile considering, you know, could she withdraw the 600 and just apply for the bridging visa E with work rights on the basis that she's making arrangements to depart Australia through pursuing this family law action, and just continue to renew that while the family law proceedings are ongoing. She could apply for special benefit from Centrelink in her child's name to support herself financially while her family law proceedings are ongoing. So if she wasn't aware of that already, maybe that may reduce her need to work, although special benefit is definitely not enough money to survive on in Australia, so unlikely. But there's some of the considerations that I think we would probably be going through with her at legal aid. So in terms of what if you can't get Medicare, what do those people do who aren't eligible for Medicare if they have medical needs while they're in Australia? The fees and charges from public hospitals under their policy guidelines can be waived for some groups of people. So there's a New South Wales health policy for fees and charges for patients ineligible for Medicare, and they can be waived if the patient's a victim of crime, if they're an infection control risk like a COVID-19 situation, if they're from a country with a reciprocal healthcare agreement. So I've listed some of the countries there in probably quite tiny writing for you. If there is a high-risk pregnancy issue that the person has, or if they're an asylum seeker or immigration detainee. And unfortunately, I guess if you don't meet those categories, you generally have to pay for the medical treatment, except in special circumstances. Okay, so turning to school fees, which we sometimes get asked about in relation to whether or not people can access schooling in Australia or get told their child can't access schooling in Australia. So in terms of, there's no residential restrictions to access schooling. The issue is normally the fee payable. So government schooling is free of charge, and unless you are an overseas student, and that is defined quite specifically, depends on your visa type. In short, like if you hold this visa type, you are an overseas student. And the school fees that you might have to pay if you're an overseas student are listed out there below, about $5,600 for primary school, and senior years would be $6,400. So that's sort of what people are looking at in terms of whether or not they can access the free of charge government schooling or not. Different rules if it's not a government school, but that's kind of the policy on school fees. And apologies, some of this is related to New South Wales. We've just seen in the chat for fee waiver policy for hospitals or schools outside of New South Wales. I would say have a look at the fee waiver policy in your local state, but this is applicable to New South Wales. So school fees in terms of exemptions. So the student visa holders sometimes present difficult situations for us if they've applied for a protection visa, but they still hold their student visa, because the student visa holders are administered by the International Student Program, and there's really no fee exemptions possible. The student visa, well, I guess the temporary visa holders, so if you're holding or applying for one of these visa numbers, which I've sort of put them all out there, you're not eligible to apply for the exemption from the temporary residence program education fee. If you hold a bridging visa, because you've also applied for one of those, you're not eligible to apply. If it's not one of those, then you should be able to apply for the exemption. But that's the Department of Education's sort of policy under their guidelines about who's able to get the exemption and who's not. So if your visa subclass is administered by the temporary residence program, then there's a phone number you can call then to ask what the situation is. But if it's a student visa issue, it's administered by the International Students Program, and that's who you'd need to speak to. Case study. Mariam recently applied for a protection visa onshore for herself and her son. They both hold BVAs, bridging visa A's, which haven't yet come into effect. They both currently hold student visas. However, they may be cancelled as Mariam's been cut off by her family after she told them about her religious conversion. She can't afford to continue her studies, so her student visa may be on the pathway to get cancelled. It has not yet been cancelled, and she's been told she'll need to pay school fees if she wants her son to attend school. Is that correct? Any thoughts on what might happen here? So in relation to what might happen here, we've had different experiences with this situation. Sometimes the school somehow mysteriously just offers education without the fee being payable. So that sometimes for some schools, we've found that to be successful, showing proof that they've applied for a protection visa, and it may seem to be assessed on individual principles, assessing that this person is eligible. If the school's not willing to offer free education in that way, in that sort of informal workaround, she could ask for her visa and her daughter's student visas to be cancelled voluntarily. So that would be that she would request cancellation in writing to the department, and then if the student visa is cancelled, then the client would need to apply for a bridging visa E and a bridging visa E with work rights. So for pre-COVID, when we were seeing people face-to-face, we would get the person to sign 2 bridging visa application forms, one to apply for the bridging visa and then one to apply for a bridging visa with work rights. And then on that bridging visa with the work rights, Mariam's daughter could then access the free education and Medicare in Australia on the basis of being a protection visa applicant. NDIS and housing. So pretty much you need to be a permanent resident, citizen, or the protected New Zealander in order to access the NDIS. So it makes clear that to access the scheme, you have to live in Australia, be one of these 3 groups, and meet the residence requirements. And similarly for Department of Housing, you have to meet the policy, which is permanent resident, citizen, or protected New Zealander. I guess just returning to those 2 issues, sometimes we have had one issue that can pop up for our family violence clients is them being refused public housing on the basis that they came in on a sponsored visa, the partner visa. So that's normally resolved through a letter or 2 to explain that although they hold a sponsored-based visa, their sponsorship broke down, they were granted it on the basis of family violence, and that should then be sufficient for them to access public housing once they hold their permanent partner visa. In terms of referrals, who can help with these kinds of issues, I just wanted to run through some of the organisations that are out there that are sort of, so Welfare Rights Centre, I've given the number for the Sydney organisation there. They're fantastic on Centrelink eligibility. They're specialists, they really know their stuff. They can sometimes also be quite helpful in referring things on internally to Centrelink if it's an issue that can be resolved fairly straightforwardly. SRSS payments, SRSS applications, I think someone's first port of call should be the provider themselves to make the application. If they run into problems, they could contact us at Legal Aid, for example, to get advice on what's happened. But to start the ball rolling, or if they've been cut off from payments, they should be contacting a provider to try and get back on as quickly as possible. If it's a help for family violence for a victim of violence who's on a temporary visa, the Red Cross is a great starting point. And then they, under the current project that we're working with them on, can refer clients to us through our domestic violence unit and then on to family law or immigration, depending on which parts of the problem we can help them with. For advice on immigration, social security, NDIS, there's there's Legal Aid Government Law team. We've got a team that does immigration. We've got a social security team. We've got an NDIS team. We've got a refugee legal team that helps people within the first 5 years of arrival on humanitarian and refugee visas. And if people wanted to start applications, like they haven't actually run into problems yet, they just want to apply, then normally it's an access request through the NDIA or Department of Housing to say, I need to access public housing. And I now will go back over the questions in the chat to see what I've missed while I was sort of running you through a lot of that information. And feel free to add any further questions in the question box now, and we can see where we go. Okay, let me see. I think Judy Burgess has asked a good question. Is there still only a 2-year wait for FTB and other child-related payments? There was legislation to make this 4 years, but I'm not sure if it passed yet. So FTB is a bit complicated because it's got Part A and Part B. There's no residence waiting period for Part B, and I think there is a newly arrived residence waiting period for Part A. Let me just double check how long the Part A one is. It is 52 weeks, so it is, yeah, 52-week newly arrived resident waiting period for Part A. A really good place to, and I did want to spruik the guide to Social Security law, which is my go-to place to actually source the basis for the legislation with Social Security. So I can pass around the link with the paper, but if you Google Guide to Social Security Law, and then the first search result in that should take you there. There's a section there called Citizenship Visas, Assurance of Support, Section 9, and 9.2 has visa subclasses and payment eligibility, and it runs through each numbered visa subclass. and what possible payments a person could receive on that, with a link to, I mean, it's acronym heavy. It's got newly arrived residence waiting period or qualifying residence period, and you'll have to double click on those to work out what they need if you're not dealing with this all the time. But it's quite useful because it goes through the visa subclass number, visa name, whether it's permanent, whether it's a temporary visa, whether there's an assurance of support, whether it's sponsored or nominated, what payments the person residentially could be qualified for, and then additional information, notes on what might be an exception. So if you did want to have a shop around in terms of when you've just helped a client get a visa and you wanted to know what payments they could get from Centrelink, I highly recommend that payment eligibility table in the Guide to Social Security Law website, which is their policies, like their legend that's publicly available. And at the bottom of each screen, it has a link to, or not a link to, but it has the source of that legislation or legislative instrument, or if you did want to get into more detail about it, it can be there. A couple of people have asked whether they can access the slides. Yes, so the video of this presentation and the slides and the paper that I've prepared, which sort of goes into a bit more detail about the source, will be available by the end of this week, probably in a few days from today. Let me see. I will see if I can send a link in the chat to the payment eligibility table. Question from Monique. We had an employee who's on a partner visa and he's being abused. Anti-slavery said they couldn't assist, and so did IAC because her income's too high. Who could she go to? Look, legal aid, as I guess IAC and anti-slavery would be happy to give advice. We have a means test for legal aid for grant representation. So if someone is above our means test and they're not eligible for any discretion, we have to refer them out to private solicitors, private migration agents. But if you wanted to send them to legal aid to see if they would meet the means test, we'd be happy to assess them. There's also a means test indicator online publicly where you can punch in the amount of your income, the amount of your housing expenses, how many children you've got, and see if you're likely to be eligible, to see if it's worth your while to apply for legal aid, or if it's probably likely to be refused on the means. HTTPS. Okay, I think that's the link. Sorry, just going back over some questions. Applicant applied for carer visa onshore, got a bridging visa A without work rights. Is the person eligible for Medicare? Look, I guess for applying for a permanent visa onshore, the source of that rule is the Health Insurance Act. So there's a section that says that a non-citizen is eligible for a Medicare card if they've applied for a permanent visa, if it's not a parent visa, and who hold work rights on their bridging visa. So unfortunately, you're not eligible unless you can have those work rights changed on that bridging visa. So if it's not an applicant for a protection visa, the issue would be compelling need, and it would be an application for a bridging visa, a new bridging visa, which essentially changes the conditions to have one. And I think the way it's expressed in the Health Insurance Act is the definition of an Australian resident is someone who is a holder of a temporary visa and in respect of whom an authority to work in Australia is in force. So unfortunately, if you are claiming Medicare on the basis of being an applicant for a permanent visa, you do have to have work rights on your bridging visa in order to get access to Medicare. We have had clients report a range of experiences in having that understood over the counter at Medicare. So sometimes we will help people with a letter of support, just pointing out the actual authority for the person's eligibility for Medicare under that Health Insurance Act. And it's not unheard of for there to be errors, I guess, in many aspects of the law that we've talked about today. So if people are finding that what they've been told by you is not matching their experience over the counter, they may need to agitate in order to access the sort of rights and entitlements that exist for them. Yasmin, are there other questions that you think I've missed? I'm just sort of gleaning over the table there.
No, I think you've covered
a lot of that.
I think one's maybe just come in.
Oh, nice one for Ash has commented that the 173 and 884 visa holders that have applied for permanent visa are eligible. And Collins pointed out, if bridging visa has no work rights, they could get Medicare if another person, being the person's spouse, parent or child, is an Australian citizen or the holder of a permanent visa under that Act. Yeah, so that's right. So if you're the family member of an Australian citizen, that's a different way of getting eligibility for Medicare outside of the applicant for permanent visa section. So that would be the temporary residents covered by a ministerial order. There are some categories there, and there are some partners of Australians. So yeah, if the bridging visa has no work rights, get Medicare if another person, being the person's spouse, parent or child, is an Australian citizen or the holder of a permanent visa under that Act, is a different way of getting access to Medicare. So I think just unpacking that comment of Ash's, the 173, that's the contributory parent temporary visa that have applied for permanent visa are eligible for Medicare. Yes. And that's the 884 contributory age parent temporary eligible. And then sometimes people try and get out of it. If you hold the temporary and have applied for the permanent, you're eligible for Medicare. And then I guess sometimes there's a consideration whether they want to apply for a visa that doesn't have the word parent in it in order to get around the ineligibility for Medicare for most parent visa applicants who are in Australia waiting for quite some time. I think we might leave it there because I don't want to get even more technical right at the end and confuse and bamboozle people, but I do love to do that. So I guess I will send around the materials after this presentation in sometime in the next couple of days. If you have a particularly curly issue that you'd like to bounce off with us, feel free to get in touch. If you'd like to refer us a client, that's the government law phone number at Legal Aid, or speak to our support staff by calling that number and asking how to best refer us a client. Yeah, we're always happy to help with, I guess, inquiries or situations for people that don't quite seem quite right. And yeah, there are specialist teams at Legal Aid, including my fabulous migration team, the Social Security team, the NDIS team, so happy to get in touch. All right, Yasmin, might leave it there.
And thanks so much. And just wanted to give you a big thank you for your time today and taking the time to do these sessions. They're really, really important. And if anyone watching does want their own talk for their organisation or community group, Legal Aid is also able to provide specific talks on legal topics. We're also on social media, so please look out for us on Facebook, on LinkedIn, and now on Instagram at legalaid_New South Wales. So definitely give us a follow as well if you want to stay updated on legal information and more community legal education sessions. Have a good day, everyone.